Privacy not included. Federal law lags behind new tech. Hey everyone, my name is Eric Barr with Computer Science 313. The textbook I'm going to be using is Technology, Social Media, and Society. That's with authors Liz Friedman and Daniel Middleman. We're going to be using the 22nd edition of the textbook and going over chapters 4, section 5, and pages 85 through 88. All right, let's get started. So these are the learning objectives for this section. You want to be able to understand what HIPAA legislation covers in regards to consumer-generated health data. You want to be able to identify the key weaknesses within HIPAA law when technology is incorporated. And lastly, you want to be able to find the relationship between privacy and convenience with health apps. All right, here's the overview for this section. This is essentially protection of consumer app data. It varies. You're walking through an open door. There's too many complaints to pursue. In HIPAA jurisdiction, there's some pitfalls there. You're probably asking yourself, what is HIPAA? What does HIPAA even stand for? So it stands for Health Insurance Portability and Accountability Act. It is a landmark patient privacy law that was enacted in 1996, and it's still around today, and it's used vastly in the medical and health environment. It covers the transmission of patient identifiable information between the patient and the primary care provider, or like your doctor. It also covers the transmission of information between the patient and the insurer or the data clearinghouse. That's on page 85 of your textbook for the definition there. So the agency that actually enforces this federal law is the Office of Civil Rights, and that's under the Department of Health and Human Services. So definitely a credible department or agency there. All right, so protection of consumer app data varies. So users are generating these health data at an unprecedented rate due to technology recently, whether it's mobile apps or Fitbit. And many times they just don't realize that this health data is not under jurisdiction of health privacy protection. And so things that fall outside HIPAA jurisdiction, that would be like Fitbits or home test kits like paternity tests. You can buy this at Walgreens or any local drugstore, and it's all outside the scope of current HIPAA legislation. So the textbook goes over the Privacy Rights Clearinghouse study of 2013. And this study goes over 43 paid and free health and fitness apps. And they were assessed for varying levels of consumer health data protection. And it found some very interesting things. So the researchers concluded that users should not assume that their data is private, especially in the mobile app environment. It also found three key things. So one, they found that there was non-existent privacy policies within these apps. It also found that there was apps that had the inability to accurately describe how that they were collecting or even transmitting users' health data. And they also found apps that were connecting to third-party websites without the user's knowledge and then sending their health data in an unencrypted format. So you're essentially balancing a convenience versus privacy. So in the current landscape, it only HIPAA covers the transmission between the provider and the patient. And this loophole, unfortunately, undesirable people can target this loophole. So for example, vulnerable populations such as a pregnant mother wearing a fetal monitor utilizes a non-secure Bluetooth technology to send push notifications to her cell phone. So that's a convenience, right? To have push notifications sent to your cell phone, but there's no privacy there, unfortunately, and that's not covered under HIPAA. So things to be cognizant of. And you're essentially walking through an open door. So 23andMe is a genetic testing website, and results from that website were mixed up between consumers, and their personal data was essentially compromised due to the stringent consumer protections from this loophole. The lack of enforcement from the Department of Health and Human Services is due to this loophole. And a little background on that compromised data. Genetic background results for customers were mixed up in the lab, and as many as 96 customers were given wrong DNA test results, sometimes even in the wrong gender. So company officers for 23andMe, they offer little solace for those affected by the data breach due to the lack of oversight and, frankly, punishment. So Kate Black is a corporate privacy officer for 23andMe, and she stated that they try to provide more protection than HIPAA would require, which currently is none. So hacker or poor security measures. So home paternity test results were available to anyone by simply altering URL data. And this was discovered by a Florida woman when she purchased a home paternity test kit and simply messed around with the URL data. And so she was able to access over 6,000 other women's results by doing so. She was shocked when she learned that HIPAA does not govern the product or the website. And when she complained for the data breach to the Office of Civil Rights, they responded that they have no authority to investigate the breach and that therefore that they would be closing her complaint. In her defense, she stated that it wasn't hacking because she was able to download the test results, but she was merely walking through an open door. There's too many complaints to pursue. This moral and ethical issue between the consumer-generated health data is occurring due to lack of personnel rather than lack of interest. So the Federal Trade Commission versus the CBR Systems, Inc., that was a case in 2013. It was a victory for consumer privacy and identity protection. The deputy director of the Office of Civil Rights essentially says that there's no lack of interest on the matter, but it's merely that the agency is barely able to keep up with the complaints that fall within the jurisdiction of HIPAA, let alone matters that fall outside of jurisdiction. The victory between the FTC and the CBR systems occurred in 2013 for failing to secure patient identification at a blood bank where parents store umbilical cord blood of newborns. Due to this case, CBR must undergo comprehensive independent audits for every other year for 20 years, and it must establish a more robust security measures. So definitely a victory there for consumers. Furthermore, the FTC states that consumers must be diligent in protecting their health data, as this problem is much larger than merely a company storing your health data. They state that companies can sell or share patient information without their knowledge. So it's far larger than merely storing your data. Thus, if a consumer's lack of knowledge on the incidents is occurring, this causes a lack of awareness to complain to the proper agency. So pitfalls to HIPAA jurisdiction. So companies that process genetic information like 23andMe, fall outside the jurisdiction of HIPAA as well. And roughly 60% of complaints reported to the Office of Civil Rights are not acted upon due to factors including lack of jurisdiction. Privacy practices of consumer-generated information, they vary greatly between mobile apps, and it is a burden to regulate under the current legislation. So, summary. Protection of consumer app data varies. HIPAA, or Insurance Portability and Accountability Act, doesn't have any jurisdiction in regulating a consumer's health data that's being generated, especially in the mobile app space. You're essentially walking through an open door. The consumer will have to balance privacy versus convenience when using technology, and you need to be, as a consumer, diligent to protect your own health data whenever possible. There's too many complaints to pursue. According to the FTC director, this issue is not one due to lack of interest in privacy protection, but due to lack of personnel. And lastly, HIPAA jurisdiction pitfalls. The consumer should be extra careful when dealing with sensitive data like genetic information with companies due to the lack of jurisdiction with HIPAA, because genetic information, it does not change at all, like such as when you using data that's generated by a Fitbit. So you need to be extra careful there. And finally, as more health and fitness apps become popular, along with innovations with hardware wearables such as Fitbit, the need for consumers to be cognizant to protect their health data is ever growing. And that is the end of the chapter. And finally, I'm going to end with my opinions or thoughts. And thank you everyone for watching. Is there a solution to this? Yes, I believe so. HIPAA hasn't kept pace with the current technology advancements. So essentially, HIPAA should be altered to keep up with technology that consumers have grown accustomed to over time. So there needs to be like an amendment put into it. Consumers need to band together to fight to have HIPAA changed. Should user-generated health data be treated under the umbrella of HIPAA? It most definitely should be. It is identifiable patient information, so it should be put under HIPAA. It just hasn't been included. It's kind of fallen to the wayside over time, essentially. And future implications. As time progresses, more and more health and fitness apps will become popular, and that means more and more user-generated health data will be created. So there will be a need for protections and privacy protections to be put into place for consumers. So that's my thoughts on this section. I hope it was helpful.